Let me bring in MSNBC legal analyst Danny Ceballos now. Jill Wine-Banks is an MSNBC contributor. She's also a former Watergate prosecutor. And former federal prosecutor Seth Waxman is with me as well. Mr. Ceballos, let me start with you. A lot to try and break down here. But first of all, just in broad terms, how unusual is it for officials to raid an attorney's office?
It's unusual, but it's not unheard of. It's such a significant event, though, that the U.S. Attorney's Manual has a specific section dealing with executing search warrants at an attorney's office. And that's because attorneys have privileged information. So naturally, the concern arises that they're going to get possession of clients' privileged communications and documents which are not supposed to be seen by the public, let alone members of law enforcement. So what will typically happen is that they'll put together a taint team. The government will put together a team of individuals who are both attorneys or maybe they're agents, but the key is they are not involved with the underlying investigation. They will review the documents, put them into three piles, either privileged, not privileged, or could be privileged, and they try to sort it out that way. I mean, criminal defense attorneys like me aren't particularly thrilled with that process because the people deciding whether or not documents are privileged are ultimately the people that you don't want seeing those documents in the first place, law enforcement.
Jill, this is a raid that was not carried out by the special counsel's office. It was carried out by the Southern District of New York, officers from the Southern District. Why was this particular case handled that way, and what does that tell you? Jill?
Oh, I'm sorry. I didn't know you were asking me. It is a very good thing that they turned it over. It means that in reviewing it, it was viewed that it might be outside the scope of the jurisdiction of the special counsel, so it went to the jurisdiction that has power over the offices of Michael Cohen. It also is a way to protect, although you have a taint group within the office that will look at these documents to make sure, it really protects Mueller's investigation from any question of taint from having had any attorney-client privileged documents. So it will protect the investigation of the Russia focus by looking at the crimes possibly committed by Michael Cohen, which involve paying off Stormy Daniels, Karen McDougal, by bank fraud, which may be involved in how he reported to the bank what the $130,000 loan was, by checking whether he even got a $130,000 line of credit for the payment to Stormy Daniels. There's a lot of evidence that could be in his office, his home, and anywhere else that they searched, his hotel room.
Seth, I know that when you were at DOJ, you investigated attorneys for criminal conduct, a number of them, at least 3. Give us a primer on that process.
Yeah, so when I was at DOJ, I did 3 or 4 cases where attorneys got embroiled in wrongdoing, and there is a very thorough process, as Danny was mentioning. You have to make a submission in writing as a assistant U.S. attorney at one of the satellite offices to the Main Justice Office. There's the Office of Enforcement Operations. There's a unit within Main Justice that considers these types of applications, and you have to come with real evidence. It can't be a he said, she said. It has to be something substantial because DOJ, like everyone else, is very sensitive to breaching the attorney-client privilege. Once you make that submission, and if it's approved and it's been approved within your office, then you can move forward. But of course, here we have the President of the United States, so we see even a much higher level of review going up to Rod Rosenstein, and of course now officials over at the Southern District of New York. So it is never taken lightly when you go after an attorney-client privileged piece of information, one, because it's sacrosanct in many respects, putting aside any exceptions, and 2, from the prosecutor's perspective, if they screw that up, if they somehow see evidence that they're not supposed to be, that causes a huge problem down the line because there's something called the fruit of the poisonous tree, which any evidence that flowed from that was wrongfully obtained can be thrown out, and you have issues where prosecutors or FBI agents could be removed from the case if they are so tainted that they can't otherwise function with untainted evidence. So it's a very specific process, one that attorneys and FBI agents, prosecutors take very seriously, and it is well established within the Department of Justice.
Seth, the U.S. attorney in New York is a Trump appointee. The Deputy Attorney General, Rod Rosenstein, also a Trump appointee. Robert Mueller, not appointed by Trump, of course. He is a registered Republican, hired by the deputy AG. The political bias that the president has alleged time and time again, do you see that?
Absolutely not. I don't see that occurring at all. I mean, for all the reasons you just stated, that these are Republicans. The second point I would make is, for the process I just described, there is a unit within the Department of Justice that has career prosecutors that are the initial reviewers of these kinds of applications in routine cases, and I'm sure they were involved in this application as well. Those are prosecutors who have been doing this for whether it's 5, 10, or even more years, and they have no political bent. And just as a side point, you know, when I was an AUSA, an assistant U.S. attorney, I didn't know the political leanings of 99% of my colleagues, maybe my closest friends or 1 or 2 others, but it just wasn't something that came up in conversation. You have too much going on. You have too many things that are to accomplish that are very important matters, and in this case, of course, involving the President of the United States. It just wasn't something that came into the discussion.
Danny, the president has called this a witch hunt on a number of occasions. So far, though, the investigation itself has yielded 5 guilty pleas among them, I should note, the president's first national security advisor, Michael Flynn, 18 outstanding indictments, including the president's former campaign chairman, Paul Manafort. Could the investigation have gone this far without evidence of any wrongdoing?
That, sir, is what we call a leading question. Because, as we know, you cannot get indictments without some evidence of a crime. And to even plead guilty to a crime, you need to put facts significant on the record to support that guilty plea. So we do know that to date there has been evidence linking individuals to crimes. This most recent step, a search warrant executed at an attorney for the president's office, is so significant because, given the levels of review that we've already talked about, you can guarantee that agents and attorneys in this case went above and beyond the normal probable cause required, because the law sort of it makes you rule out everything else. The U.S. Attorney's Office will rule out everything else before they get a search warrant for an attorney's office, and even more so in the case of an attorney for the president.
Jill, drawing your experience here, Herbert Kalmbach, personal attorney, Richard Nixon, ended up going to jail. Parallels here with Michael Cohen?
It's him and also the tax attorney for President Nixon, who helped him fudge up some tax claims that were not justified, also went to jail. So yes, these are people who were advising in a personal capacity. Mr. Kalmbach's crime was really related to hush money and not to his legal representation. So that's a slight difference, although, again, Cohen is involved in hush money. I'd also like to point out, in terms of the search warrant, that a judge approved it. It wasn't just a decision by the top of the Department of Justice, by the U.S. Attorney for the Southern District of New York. It was approved by a judge. A showing of probable cause had to be made. And as Danny said, in a case involving the president or the president's lawyer, a prosecutor is going to take extra precautions. Before returning an indictment in Watergate, we believed we had to have much more evidence than just probable cause in order to ever get a conviction, and we wouldn't have returned an indictment if we weren't assured that we thought we had a very high probability of getting a conviction. The president gets an extra benefit of a doubt. So in this case, you can imagine how much evidence they had in order to go before a judge and argue for a search warrant of the president's lawyer's offices, home, and hotel room.
Jill, thank you. Danny, thank you. Seth, a big thanks to you as well.